Ladies and gentlemen, welcome and good afternoon. Thank you for taking the time to be with us today, and a very warm welcome to the M&A Academy program, our third webinar in the third edition of the program. My name is Sameer Shah, and I'm an M&A partner in Khaitan's corporate M&A group. Once again, a very warm welcome to all of our audience, whether attending live, whether in India or across the world, or if you are seeing a recording of this separately on YouTube. For people who may be attending this program for the first time, this program has been designed to impart foundational legal knowledge and understanding on M&A transactions and processes in a corporate training-like environment for corporate executives, in-house legal teams, and others participating or interested in M&A in India today. Our subject for today's webinar is dispute resolution options in M&A transactions. This is a topic which has come up in the past in several different webinars in the form of Q&A, and therefore we thought it best to dedicate a complete webinar to this. Today's webinar is important because M&A deal activity in India has been on the upswing for the past several years, unfazed and undaunted by otherwise troublesome global headwinds. This includes domestic transactions as well as cross-border transactions. And given the entire focus of documentation in an M&A deal tends to be towards risk allocation and risk mitigation, the question is, what do you do when one party refuses to live up to its end of the bargain? We will answer that today and also discuss how the seeds of this question and this answer need to be sown within the transactions ecosystem right at the outset. And therefore, this forms a very key part of the entire strategy at the inception of the transaction. As always, we will have a formal presentation followed by Q&A. So please feel free to keep submitting your questions using the Q&A chat box. We already have several questions from our pre-registered attendees. We will respond offline over email after the webinar if we are unable to capture all the questions today. And as is our usual practice, the presentation, the summary notes, and the recording will be shared with all participants, and the recordings will also be uploaded on YouTube for future reference. Next slide, please. To introduce our speaker today, we have with us my partner Anushka Sharda. She is a disputes partner based in our NCR offices, although she advises clients on disputes nationally as well as internationally. She has more than a decade of experience in the field of dispute resolution. We circulated her profile over email to participants, but just to mention once again, she is an experienced and knowledgeable practitioner and has advised several large clients on their M&A disputes. So without further ado, ladies and gentlemen, I now invite Anushka to deliver her presentation. Anushka, over to you, please.
Thanks, Sameer. And thank you to all the participants for taking out the time to join this webinar. Now, as Sameer indicated, the agenda for today's webinar is to discuss the different dispute resolution options which are available to stakeholders in case a dispute arises in an M&A transaction, the pros and cons of each option, and our recommendation on how parties may structure their dispute resolution clauses in contracts to best safeguard their interests. Next slide, please. Now, before we dive into the different dispute resolution options, for better context, it will be relevant to understand the different types of disputes which often arise in a M&A transaction. For ease of understanding, we have divided them into three stages of a M&A transaction. Firstly, the pre-signing stage. Now, this is the stage prior to signing of the share purchase agreement. Post the handshake deal, typically the first document agreed to between the parties is the term sheet or the LOI. The primary purpose of such a document is to set out the principal terms and conditions agreed to between the parties. Now, whether the term sheet creates a legally binding relationship between the parties and to what extent depends on the wording of the document. However, generally sellers will insist on the confidentiality clause to be binding, as they will not want to risk the buyer using the information they have gained access to in the due diligence to be disclosed to third parties or be misused for any other purpose. At the pre-signing stage, therefore, most of the disputes relate to breach of confidentiality clauses. Now, our key takeaways are this, that for parties to protect their interests, it is vital that not only does the term sheet clearly spell out the provisions which are intended to be binding, but also provides for a governing law and dispute resolution mechanism to best safeguard their interests. Now, the next stage is the stage between signing and closing. As we know, closing is the event when the shares are actually transferred from the seller to the buyer. This is the stage where we see the least number of disputes taking place. However, the possibility of one cannot be ruled out. Between signing and closing, disputes may arise over non-fulfillment of conditions precedent or other contingent obligations set out in the agreement, such as obtaining relevant approvals or placing consideration amounts in the escrow arrangement, etc. This brings us to the final stage, which is the post-closing stage. It is most common for disputes to arrive at this stage between the parties. Such disputes often involve disagreements over, for instance, interpretation of price adjustment clauses. Now, what are price adjustment mechanisms? The valuation of the company may fluctuate significantly in the period between signing and closing. To ensure the sale consideration which is paid is aligned with the valuation of the company at the time of closing, parties often agree to price adjustment mechanisms in the SPA. Interpretation of these clauses often result in disputes. Secondly, disputes may arise over obligations of a party to make contingent payments within a certain period of closing. Thirdly, disputes may arise over breach of representations and warranties which the parties have made to one another. Now, with this, let's look at what are the dispute resolution options available to stakeholders of a M&A transaction. Negotiation, mediation, and conciliation are the non-adversarial options, with expert determination lying somewhere in between, depending on the terms of appointment. Arbitration and litigation, of course, fall in the bucket of adversarial options. The best part about having the availability of multiple avenues for dispute resolution is that parties can choose which option, or most often combination of options, works best for them. This largely depends on their relationship with the other party, business and commercial needs, and most importantly, the nature of the dispute which has arisen. Now, once the dispute arises, the first recourse to resolve the same should ideally be through negotiation. The process of negotiation involves the parties themselves discussing the issues and arriving at a settlement without any third party involvement. What is most enticing about negotiation is that parties are in complete control of the entire process. Our firm, for instance, recently conducted an extensive survey on current trends in domestic arbitration in India. The respondents of the survey were in-house counsel and corporate executives with a wealth of experience in dealing with corporate disputes. Interestingly, but not surprisingly, negotiation emerged as the preferred method of dispute resolution for the majority of the respondents. Now, as we know, negotiation is not governed by any formal rules or statutory framework. Therefore, in our view, parties may consider the following factors at the stage of drafting of the agreement itself and once the dispute arises to maximize the benefits of negotiation. Firstly, parties need to consider whether to make negotiation a mandatory or a directory precondition to invoking a formal dispute mechanism in their contract. A mandatory precondition would imply that without exhausting the mechanism of negotiation, a party cannot, or at least ought not, to invoke arbitration or approach courts for relief, as the case may be. We have seen in our experience that there are advantages and disadvantages of having non-adversarial dispute resolution mechanisms as a mandatory precondition. The advantage, of course, is that many disputes may be resolved through negotiations itself. And as we discussed, negotiation is the most preferred option for dispute resolution for businesses. However, on the flip side, we have seen cases where preconditions can also become barriers and be used as delaying tactics by one of the parties to the dispute. Now, whether exhausting the non-adversarial remedy agreed to between the parties is a mandatory or directory precondition has itself been a subject matter of many disputes, and there are conflicting judgments by various courts on this issue. However, a common theme is of courts looking at the wording of the clause to gather the intent of the parties. For this reason, it is very important for parties to carefully negotiate and draft their clause to ensure that their intent is accurately captured in the agreement itself. A question may arise in your mind that what happens if a party is in need of urgent relief, but the contract provides for preconditions to first be complied with? In this regard, there are case laws which hold that in case there is genuine urgency involved or the correspondence between the parties makes it clear that going through the preconditions would be a mere formality without any possibility of the same yielding any results, the preconditions to arbitration or litigation in such circumstances can be given a go-by. Therefore, depending on the jurisdiction you are in and your specific facts and circumstances, one needs to carefully strategize both at the stage of drafting the dispute resolution clause and once the dispute arises, what the most suited course of action should be. Now, secondly, parties should in their agreement consider contractually requiring senior executives from their organizations with decision-making power to take part in the negotiation. Before the negotiations begin, parties should consider laying down specific agenda points for discussion so that they are able to arrive at clear solutions and actionables. And lastly, parties may circulate minutes of every session of the negotiation. But in case they intend to do this, they must make sure that the minutes are agreed to be confidential and without prejudice in nature, because without this, parties will not be able to have free and honest discussions. Now, compared to negotiation, mediation is a far more structured process where parties use the services of a neutral person who specializes in structured communication and negotiation techniques to try and arrive at a mutually acceptable agreement. It is important to note that a mediator does not play the role of an adjudicator. A mediator is not a decision-making authority and cannot bind the parties without their consent. There are different forms of mediation which may be relevant from a M&A disputes perspective. Firstly, parties may opt for a private self-driven mediation outside of any statutory framework. One of the most successful use cases of mediation I've seen in the last few years was in a dispute between a PE fund investor and promoters of a company. The investors had a right of exit at a pre-agreed price if the company did not achieve an IPO within 2 years of their investment. The promoters did not honor their exit right, stating that the IPO was delayed on account of actions of the investors themselves. After several rounds of discussions and time spent, the investors filed a reference to arbitration with SIAC, which was the agreed arbitral institution in the contract. This action immediately triggered serious settlement discussions between the parties, and the parties used the good offices of senior people in the industry to mediate, and within a month, parties were able to arrive at a settlement. Therefore, the importance of mediation as a dispute resolution mechanism, especially in combination with other methods of dispute resolution, cannot be overstated. The second option is that of mediation under Section 12A of the Commercial Courts Act. Now, M&A disputes are commercial disputes under the Commercial Courts Act. Therefore, in case parties have not agreed to dispute resolution through arbitration, they have the option to refer their disputes for pre-litigation mediation under Section 12A of the Act. The third option available to parties, or which should soon be available to parties effectively, is the Mediation Act of 2023. Now, in a push to mediation in India, the Mediation Act was passed last year. We need to be mindful that most of the provisions of the Act are not yet in force and therefore have not yet been tested in courts as well. However, we are expecting the provisions to be notified soon and will therefore spend some time on the Act. From the perspective of M&A disputes, some of the provisions of the Act are interesting. For instance, If the parties arrive at a mediated settlement agreement under the Act, the same can be executed in the same manner as if it were a judgment or decree passed by court. This is a huge advantage as parties don't need to go through the rigors of litigation or arbitration for enforcement of the mediation agreement and can straight away execute the same, unlike a private mediation outside of any statutory framework. The Act also provides that matters relating to the mediation proceedings are to be kept confidential, with the only exception being that where the disclosure of the agreement is necessary for the purposes of registration, enforcement, or challenge. Timelines for proceedings are provided for in the Act. Further, the Act says that the mediation agreement can either be in the form of a clause of a contract or a separate agreement and can be entered into prior to or post the disputes having arisen. Therefore, parties don't need to lose their sleep if the agreement itself does not cover a reference to mediation under the Mediation Act. Lastly, the Act also provides for appointment of mediators. Parties are free to agree to appoint the mediator on their own or can request a mediation service provider recognized under the Act to appoint the mediator. This is a very important provision as parties can now ensure appointment of a neutral mediator through an institution, and it puts to rest any apprehension a party may have of the counterparty who may have higher bargaining power to appoint a biased mediator. However, just to remind the audience, as we discussed, the impact of the Act is yet to be seen as most of the provisions are not yet in force. Moving on to the next method of another non-adversarial dispute resolution mechanism, that is conciliation. In conciliation as well, a third party is appointed to assist the parties in settling their disputes and reaching an agreement. Conciliation is governed under Part 3 of the Indian Arbitration and Conciliation Act. However, although arbitration and conciliation are governed under the same Act, it must be borne in mind that conciliation is a non-adversarial mechanism as opposed to arbitration, which means that a conciliator cannot bind the parties with his or her decision. Now, Part 3 of the Act lays down the procedure required to be followed by parties in respect of conciliation. It's a simple procedure which includes sending a written invitation to the other party to participate in conciliation proceedings, appointment of a conciliator, submission of brief written statements by the parties if the conciliator requires the same in his or her discretion, and finally, if terms of settlement are arrived at between the parties are required to enter into a settlement agreement and both the parties must sign the same. Now, most importantly, if a settlement agreement is arrived at, it is considered to have the same status and effect as an arbitral award on agreed terms and can consequently be enforced as a decree of a civil court. Luckily, Indian courts have had the opportunity to test the legal validity and enforceability of conciliation agreements. We are going to discuss a case where the agreement was held to be enforceable and another where enforcement was refused. For instance, in the case of Harish versus State, Supreme Court refused enforcement of a settlement agreement as the conciliator had not followed the procedure laid down under Part 3 of the Arbitration and Conciliation Act. However, in my view, this was a very extreme case where the conciliator had drawn up a so-called settlement agreement without the consent of one of the parties, without the agreement bearing both the parties' signatures, which of course resulted in Supreme Court refusing to enforce the same. In another case of futuristic offshore services and chemicals versus ONGC, the Bombay High Court held that the conciliation agreement is not only enforceable, but by virtue of the Arbitration Act, the status of a conciliation agreement has been raised to that of an arbitral award on agreed terms. With this, we move on to expert determination. Expert determination is something relatively new, which is gaining a lot of traction, especially for resolution of complex accounting and technical disputes. For instance, in the context of M&A transactions, parties may agree to refer disputes regarding the valuation of the company or purchase price considerations to an accounting expert for her opinion. Unlike arbitration, though, expert determination is not governed by any legal framework in India. The use of expert arbitration by the parties is a voluntary process which the parties may choose to contractually agree to. However, in the absence of any statutory framework, it becomes all the more important for parties to frame a robust and effective expert determination clause. For instance, parties may specify whether reference to an expert is a mandatory or directory pre-arbitral condition. Is the expert report intended to be final and binding on the parties? Whether the expert report is to be confidential in nature? What will be the exceptions to such confidentiality, if any? Parties may define what are the issues which can be referred to an expert for determination. This, to my mind, is very important as parties may not want every issue arising under the contract to be referable to the expert for determination. The contract may provide the qualifications the expert should possess. Very interestingly, parties may also consider using an institution such as CAC or ICC for making the appointment to set at bay any apprehensions regarding the neutrality of the expert. Parties may agree on the cost allocation in the contract itself. And lastly, but most importantly, the clause should clearly specify whether the expert is an arbitrator or not to avoid any unnecessary controversy in this regard. Now, to take the example of a case before Supreme Court. In the case of KK Modi versus KN Modi, Supreme Court was faced with a question regarding whether reference of the disputes to the chairman of IFCI was intended to be a reference for an expert opinion or reference to an arbitrator. After a protracted and time-consuming litigation, the court finally held that the intent of the parties was to treat the chairman's decision as the opinion of an expert and not an arbitral award. The key takeaway for me from this case is that had the parties clearly set out in the contract that the expert was or wasn't meant to be an arbitrator, the parties could have avoided time-consuming and expensive litigation in this regard. Now, moving on to an adversarial form of dispute resolution mechanism, that is arbitration. Arbitration is the most preferred option for resolution of M&A disputes for the obvious reasons that it offers confidentiality, expedited procedures, ability to appoint experts as arbitrators, flexibility, party autonomy, and most importantly, is an efficient and streamlined process, especially in comparison to litigation. We came across a recent estimate where it was surveyed that more than 75% of share purchase agreements today have arbitration clauses. However, it is very important to draft your arbitration clause well, as departing from the same at a later stage will not be viable. Some essential aspects to our mind which a good arbitration clause should include are: firstly, it must set out the scope and coverage of the disputes which are governed by the arbitration clause. For instance, if the intent is that all the disputes arising under the SPA be referable to arbitration, it must be clearly set out that all the disputes arising under and in connection with the agreement are referable to arbitration. Secondly, the clause should set out the seat of arbitration. The importance of setting out the seat of arbitration cannot be overstated. Seat is determinative of important issues such as where the challenge to the arbitral award will lie, and the law of which country will determine the scope of the challenge. The clause should set out the law governing the arbitration agreement. The law of this jurisdiction governs important issues such as arbitrability of disputes. The agreement should separately set out the law which will govern the contract as a whole. The clause should definitely set out whether the arbitration will be ad hoc or institutional, and of course, if you're opting for institutional, which institution is going to administer the arbitration. And lastly, the mode and manner of constitution of the arbitral tribunal, including the number of arbitrators. In our experience, When an arbitration clause contains all of these details, the process of initiating and continuing with the arbitration becomes much more streamlined and efficient. Now, with this, I'll share an example of a dispute over contingent payments from a recent arbitration I was involved in. This was a dispute which arose at the post-closing stage of a M&A transaction. The seller's case was that under the SPA, they were entitled to additional consideration if the valuation of the company crossed a certain threshold within 2 years of closing. Despite the formula for computing the valuation of the company being set out in the SPA, complex questions arose regarding the interpretation of the formula, which share transactions would qualify for the purposes of computing the valuation, whether the sellers were themselves in breach of their post-closing representations, disentitling them from the additional consideration, etc. Now, the SPA provided for dispute resolution through institutional arbitration, which enabled fast-track arbitrations. The award in the arbitration was passed within 10 months of the arbitral tribunal being constituted because the parties had opted for the fast-track arbitration procedures, and the entire dispute was settled between the parties within 12 months of reference. Therefore, it is very important that parties at the agreement drafting stage itself identify the right arbitral institution which would work for them. From the perspective of cross-border M&A transactions as well, we have seen arbitration emerge as the most effective dispute resolution mechanism, especially with the increasingly pro-arbitration approach adopted by Indian courts in the past. Now, just to take a few examples which Indian courts have dealt with. For instance, in the case of PASL Wind versus GE Power, the Supreme Court recently held that two Indian parties can choose a seat of arbitration outside of India. This is a big boost to investor confidence, especially because where parties involved are 100% subsidiaries of foreign entities, they would naturally prefer a neutral seat of arbitration. Secondly, I'll take the example of the Amazon Future Group case. In this case, it was held that the award passed by an emergency arbitrator appointed by an arbitral institution is enforceable in India. This judgment is also path-breaking as parties now don't have to waste time in filing fresh proceedings in India to seek urgent interim relief and can directly enforce the emergency award. Further, in another path-breaking judgment of Vijay Karya, Supreme Court recognized that signatories of New York Convention, like India, have agreed to a pro-enforcement bias, especially when it comes to foreign awards. Another important finding of Supreme Court in this matter was that Supreme Court affirmed the Delhi High Court's judgment in Cruise City and held that a foreign arbitral award directing a buyout at a discounted price may be enforced even if it is inconsistent with provisions of FEMA. Supreme Court explained that breach of FEMA would not by itself amount to a violation of fundamental policy of Indian law. These developments in the Indian arbitration space have boosted the confidence of foreign investors in respect of arbitrations carried out against their Indian counterparts. Litigation in India is unfortunately plagued with delays on account of the backlogs in courts. The time spent in litigation makes it a very inefficient and costly option. This, along with other concerns such as lack of confidentiality and flexibility, is the reason why our clear recommendation is for parties to include a reference to arbitration in their dispute resolution clauses. It is relevant to note certain important judicial trends with respect to M&A transactions. The trend earlier was to limit interference on deals finalized between the parties. For instance, the Supreme Court held that valuation of shares is a matter of business judgment and outside the scope of judicial scrutiny. Unless illegality or fraud was proven, the court could not decline a sanction of an amalgamation scheme which had been approved by the majority. However, in the recent past, we have seen courts interfering more and more in business deals. Of course, only when deemed necessary. But whenever the court has felt that the proposed scheme is for the sole benefit of the promoters or is fraudulent in nature, the court has started interfering in the business deals as well. Having discussed the various options Let's now do a comparative analysis of the dispute resolution mechanisms. Now, as we discussed, negotiation, mediation, and conciliation are good non-adversarial options. However, these methods by themselves may not always yield results. Therefore, depending on their situation, parties may want to strategically use one of these methods in combination with an adversarial dispute resolution option to maximize their chances of success. On flexibility, except litigation, unfortunately, the other forms of dispute resolution offer a lot of flexibility to the parties, as parties can contractually agree to the process which best suits their needs and circumstances. On confidentiality, an expert report may or may not be confidential depending on the agreement between the parties. With respect to arbitration, the arbitral process is itself confidential. However, if a challenge is filed in courts, the confidentiality aspect is compromised to a large extent, which is why we put a tick and a cross when it comes to arbitration and confidentiality. We have already discussed aspects regarding the enforceability of the various dispute resolution options, and therefore I will not spend time on that anymore. On speed of securing final reliefs and costs, litigation again fares the worst. This is because the longer it takes for resolution of a dispute, parties are likely to spend that much more money on the process. With the 2015 amendments to the Indian Arbitration Act, arbitration, on the other hand, is moving at a relatively much faster pace. The survey conducted by our firm revealed that domestic arbitrations are taking approximately 24 to 36 months to complete. Now, in my experience, if you choose the right institution, and in case you're going in for ad hoc arbitration, you choose the right arbitral tribunal, this time period can be further reduced. But while the arbitral proceedings themselves are to an extent within the party's control, and therefore the time limits often move faster. In case a challenge to the arbitral award is filed, the time for the challenge to be heard and disposed of by courts can be very time consuming. Now, with this, I come towards the end of my presentation to what are the key takeaways. Fast and effective dispute resolution, I think we all agree, is what everyone is aiming to achieve. In our experience, a large number of disputes settle once the legal proceedings are initiated and an interim favorable order has been obtained by one party. Having said that, there is no one-size-fits-all solution for dispute resolution. Each situation needs to be assessed on the merits and the right option needs to be chosen. Much of that assessment needs to be made at the agreement stage because different dispute resolution provisions can be considered for different types of disputes, and it may not be possible later to depart from the agreement. However, it's never too late even once a dispute arises, and parties can still be creative in finding the right solution for their dispute if both are willing. Thank you, and with that, I'll hand it over to Sameer.
Thank you very much, Anushka. That was take a moment. I think you've done an excellent job covering off a fairly dry and fairly complex subject. Sorry, I took a minute to switch on my camera because the chat box has been buzzing with questions. So whenever you're ready, we'll deep dive in straight away.
Sure, Sameer. Let's start with the Q&A.
Okay. So I'm going in no specific order, but just trying to bundle a few questions together. So there's a question on institutional arbitration and whether it's cross-border or domestic. What's the right way to choose which institution works best for you, and how do you how do you decide what's the way?
Yeah, that's a very relevant question, Sameer, and something which we actually did not cover in our PPT, and I'm happy this question has been posed. So it's very important for parties to choose the right institution at the stage of drafting of the agreement itself, because otherwise we have seen cases where parties feel like they are in a position where they are remedyless, as the institution chosen may not be cost effective, may not be situated at the right place, and therefore parties are not able to avail the same for resolution of their disputes. A few factors which they must look for in the rules of the institution while opting for the same are: firstly, do the rules, and especially from a M&A disputes perspective, firstly, do the rules provide for consolidation of parties? This is very relevant for M&A disputes, as multiple stakeholders are usually involved in a M&A dispute. There will be a buyer, a seller, the shareholders may be involved, there may be guarantors, subsidiary companies, etc. So it's very important that the rules enable consolidation of parties. Secondly, this cannot be overstated, the rules must provide for expedited procedures, and statistics are also available of various institutions now on how much time it has taken for the arbitral award to be delivered. So it's one thing to have an expedited procedure on paper, but parties must also do the homework to see that was this effectively implemented by this institution. Thirdly, of course, the rules must allow you to claim interim relief. They must, again, ensure that the procedures are kept confidential. This is something which I think most of the institutions provide for. But I, while I'm stating it last, I know for many parties it's the most important. Is the arbitral institution cost effective or not? Most of the institutions today do provide for cost calculators. So parties may make an estimate of what the dispute amount will be, and use the cost calculator at the stage of drafting of the agreement itself to see whether it will be cost effective or prohibitive in nature. So they may take into consideration all these factors, and of course, we are here to assist them with this. And taking into consideration all these factors, we can see which institution is best suited in the facts and circumstances of that particular case.
Understood. So there's a question from someone who seems to have had a bad experience with some institution, and they're saying, we have had a prior bad experience with an institution. I'm not naming the institution. Um, would you still suggest we prefer ad hoc arbitration over institutional arbitration? And I think a connected question which comes to me is, sometimes I see some parties insist on ad hoc. Why is that so? What would be a good reason for that?
So in our conversations with our clients, what we've understood is that the perception of clients, at least, is that ad hoc will be more cost effective than an institutional arbitration. This is the reason why, this is typically the reason why parties choose ad hoc over institutional. But I think this can be addressed in a couple of ways. Firstly, in case you are as I said, cost calculators are available for every institution. So you can see which institution will suit your needs the best. Secondly, however, in case you are still going in for ad hoc arbitration, you should make sure that the arbitrators you choose are people with an impeccable reputation and are fair, because otherwise there is no check or balance on arbitrators in an ad hoc procedure, which can lead to the arbitration becoming even more costly than an institutional arbitration. So to my mind, if cost is what is pushing you towards an ad hoc arbitration, then that is something which can be addressed by taking advantage of the cost calculators which all the institutions today provide.
Understood. Hot off the press, there's a question right in the chat box at the moment. Uh, if there is an SPA where parties are from India and USA both, what could be a good seat for arbitration? And they're looking for various answers, whether it's USA, India, some third neutral jurisdiction.
We have seen Singapore as being a very effective neutral jurisdiction for any dispute where one party is Indian and another is foreign. I think there are a couple of obvious advantages. One is geographically. Singapore is convenient for all parties. Secondly, over the last 10-15 years, we have seen Singapore put in place a lot of good practices. And there are enough experts available in Singapore itself whose assistance can be taken for proceeding efficiently in an arbitration. So our recommendation would typically be, in case you're looking for a neutral venue, Singapore can be considered, though that's not an exclusive recommendation, depending on what are where your lawyers are based, where is the cause of action arising, where are you placed as a party. You can, as a neutral venue, choose between Singapore, Dubai, or UK. These are three that we've seen emerging as good, effective jurisdictions for arbitration.
On Singapore, let's pick that up. So there's a question from someone saying, if we select Singapore and SEAC rules, what governing law do we recommend, and what courts would supervise the execution of any arbitral award that comes out of it, and what would be the process to execute an arbitral award out of SEAC?
So what will, in case both the parties are Indian, then my recommendation still would be to have the governing law as Indian law. You can have the seat of arbitration as Singapore, but the governing law should be Indian law, because as of today, Supreme Court has held that two Indian parties can choose a foreign seat of arbitration, but that judgment does not speak to whether two Indian parties can choose a substantive law of a neutral country. So I would advise that err on the side of caution. In case there are two Indian parties involved, opt for Indian law as the governing law. The seat now can be Singapore. Sorry, the second part of the question was which court will govern the
Execution.
So, challenge to the award, in case it is a foreign seat, will lie wherever the seat is. In case the seat is Singapore, your challenge to the award on merits will lie before the Singapore court. But execution will be dependent on where the assets of the parties are located. So, in case it is a reciprocating country like Singapore, then you can get the award to India and enforce it in India under Part 2 of the Arbitration Act. And in India also, you'll need to see where are the assets located and execute it in that jurisdiction. Now, in case there is one Indian party and one foreign party, what should the governing law of the contract be? That's a very case-specific question. You'll need to see what are in your interests as a party to the transaction and what is your bargaining power, and accordingly, of course, opt for the governing law.
Just and before we move away from arbitration as a concept, because arbitration seems to be a clear favorite, somebody is asking us, have we practically, and this is a leading question for you, have we practically seen SEAC awards being enforced and being executed?
Yes, and actually, we have had some very positive experiences, and I must clarify, it's been with Delhi High Court. And I do understand that as soon as any court proceeding in relation to arbitration also arises in India, there are severe bottlenecks and there's a lot of delay. There's a lot of skepticism that, okay, you've now got an award, but when will you see the color of money? Can you ever get it executed in India? But I'll share two examples with you. So we got one enforcement successfully done in India last year in a record period of 6 months. And typically, we would not even give such ambitious timelines to our clients. We tell our clients that an execution will take at least 1 to 2 years. However, India now has started, and Delhi High Court has been implementing it in spirit, a pro-enforcement bias, and they have been expediting execution of foreign arbitral awards. So how we worked with it was we first strategized on getting some very effective interim injunctions against the judgment debtor. Those injunctions really hampered the business of the judgment debtor. And within a few months, the judgment debtor was was at the table to settle. So I know this seems like, okay, they settled the arbitration, so it wasn't really through execution that you saw the color of money, but it was the interim injunctions which were passed by Delhi High Court in the enforcement petition, which even brought the party to the table to settle. So I
Absolutely.
think I have seen, I mean, to that question, I have seen awards getting executed in India.
And in fact, institutionally, one of the key reasons why we as a firm established a Singapore office and we now have two disputes partners sitting there is because of the prominence Singapore has acquired as an institutional arbitration choice. So I think that's out there for everybody to see. So maybe we switch from arbitration, maybe we switch back to expert determination. And you mentioned something about a reference for expert determination versus a reference for arbitration. What would be the difference between the two?
Right. So I think the biggest difference between the two is that an expert report, while parties may contractually agree to it being finally binding between them or not, it cannot be directly executed in court as a decree of a civil court. So, in case one of the parties opts not to comply with the expert report, even if you've agreed to it to be final and binding, you will need to then file either a litigation or an arbitration in order to have the same adjudicated upon and then enforced. So, for instance, a contract between parties is final and binding, and in case the party doesn't comply, then you need to go to court or arbitration to have the same enforced. So, unfortunately, because there is no statutory framework governing expert reports today, in case you need to enforce it, you will have to go through the rigors of litigation or arbitration to get the same enforced. Of course, with an arbitral award, it is final, binding, and conclusive between the parties. So, subject to any challenge to the arbitral award, it is directly executable as a decree of a civil court. That's one big difference, but also practically, the kind of issues which are referred to experts are very different than what are referred in arbitrations. Uh, to my mind, I would advise the client that in case something is very technical and requires someone like an accounting expert to uh, to be able to determine the issues, then go in for an expert determination. And as disputes lawyers here, we always assume the worst, that a party will not comply with the expert report. We will have to go in for litigation arbitration. But as we've seen, that's not the case. In case a neutral accounting expert, for instance, arrives at a genuine valuation of the company, there are good chances that parties may just comply with it without wanting to spend time and money on litigation or arbitration. So that is the biggest advantage of expert determination, that you can have a person who may or may not be from a legal background but is an absolute expert in the subject that you need determined. What happens with
Right.
arbitration is that you would actually, parties do have a preference for a person from a legal background to be the arbitrator. While we do see technical experts as arbitrators, but most often we see people from legal backgrounds being appointed. So they will, in most of the cases, not have the kind of expertise which you could get through an expert determination mechanism.
Understood. And just in terms of expert determination, do you expect it to get adversarial in practice? Um,
That largely depends on how you framed your clause, your contract. In case you have decided that this will not, in case you've decided to be final and binding in nature, then it can be used as evidence in your court proceedings or arbitration proceedings, which may follow in case of non-compliance. But if you've agreed that it's going to be confidential in nature and it'll be privileged and cannot be used as evidence, then it is completely non-adversarial, because then it's just like an opinion or an advisory to the parties. Both approaches have their pros and cons. So on one hand, a party may think that if it's not final and binding, why should I spend any time on expert determination. But on the other, parties may, for the very reason that I discussed earlier, prefer to go in for expert determination if they think that no, the expert is someone who we trust and their opinion is something which we would want to follow. So there is value in going in for an expert
Understood.
determination.
Understood. There's a question before I jump to mediation and conciliation, and I'm conscious of time. Just on foreign judgments, there's a question on enforceability of foreign judgments in India, and where do you use that, where do you not?
Foreign judgments are enforceable if it is from a reciprocating territory under CPC. So there is a notification which sets out which are the reciprocating territories. In case the foreign judgment is passed by one of those territories, you can enforce it in India. If it is from a non-reciprocating territory, then again, you can only use it as a persuasive piece of evidence in a fresh suit that you will file in India. So foreign judgment, which is again a reason why we suggest that please agree to arbitrations, because litigating even in a foreign country is going to be, it's enforcing a foreign judgment passed by a
Very
foreign
difficult.
country is
Very difficult.
also a Herculean task. So
Right.
whereas foreign awards are getting enforced in India now.
Right. Now, jumping to mediation and conciliation, there's one question. In practice, what is the difference between mediation and conciliation?
So I can honestly answer that as of today. The difference is that, of course, in a private mediation, whatever is the settlement agreement that you arrive at, that cannot be directly executable as a decree of civil courts.
Understood.
Whereas a conciliation agreement has the same status of an award on agreed terms, which means it can be executed as a decree of a civil court pursuant to Section 36 of the Arbitration and Conciliation Act. But once the Mediation Act actually comes into force, then both on paper, at least today, seem to be equally effective. But as the provisions of the Mediation Act have not yet been tested in courts, we will perhaps wait for some time and see how it plays out before recommending our clients to choose the Mediation Act over conciliation under the Arbitration Act.
And just in terms of how we usually draft these clauses, sometimes we provide for a cooling off period, maybe a negotiation, maybe a slightly more supervised adult conversation between parties. Do you recommend creating multiple tiers before arbitration or before going to court? So maybe a negotiation or a mediation or a conciliation or not? How do you, what's the secret sauce? How do you decide?
Unfortunately, there is no one size fits all approach over here. And I'll tell you why, because as we discussed, a multi-tiered clause with non-adversarial options being mandatory in nature could also be a barrier to a party getting effective relief. For instance, in case I invoke arbitration, the counterparty's first defense could be that no, you have not exhausted the preconditions to arbitration, and therefore your invocation is bad in law. So you need to be very mindful at the stage of drafting the agreement itself that do you want these preconditions to be mandatory in nature or not? Because there are pros and cons to both the approaches. The pros are, of course, like we saw in our survey as well, that any business will prefer a non-adversarial option over an adversarial option. And it's only a fraction of cases which actually reach arbitration and litigation. So to avoid frivolous disputes being referred to arbitration or litigation, or even serious disputes which could actually be resolved in good faith from being referred to arbitration or litigation, it is useful to have these non-adversarial mechanisms. But when we make it mandatory in nature, it could be misused by one of the parties or used also to their advantage for as a delaying tactic. So that's something which I think it needs to be a discussion between the management of the party and the councils as to what is best suited when they're for them when they're drafting the clause.
Understood. Okay. Then just going into maybe just the last two questions, and only because I'm conscious of time. Um, right. Would you have different forms of dispute resolution for pre-signing, for example, a term sheet or an exclusivity letter, versus what you have between signing or after closing of a transaction?
Typically at the pre-signing stage, the dispute which arises is over breach of confidentiality provisions. Now, for such a dispute, you need to get urgent injunctive relief. You cannot, you may spend time in negotiation, but that is post securing your interim protection. So for the pre-signing stage, which is something which should be covered in a completely separate agreement, which should be your LOI or term sheet, we would recommend having a dispute resolution clause such as an arbitration. And parties then can always and should go in for negotiation on the sidelines, but let it not be a mandatory precondition. Whereas the stage between signing and closing, while we see lesser disputes at this stage, this is a stage where parties may strategize that negotiation or mediation may be better suited to their interests, because at this stage they are far more invested in the transaction and would want to preserve their relationship. So a non-adversarial mechanism at this stage would be very useful, and also because of the kind of disputes that we see at this stage. The dispute would be over, whether a party has been able to secure approvals or not, whether they've failed to deposit the amount in escrow, etc. These are not the kind of disputes for which you typically need injunctive relief. So strategically, I would think, yes, different strategies would be applicable to both these stages. And because both will be contained in separate documents, therefore you can actually have different dispute resolution mechanisms for each of these stages.
Understood. So, like I said, last question, and this is from our registration report. Somebody wanted to understand what good practices do you recommend we follow in order to reduce the occurrence of disputes in M&A transactions?
Reducing the occurrence of disputes, firstly, enter into the M&A transaction with a trustworthy party. But that's, of course, not from a dispute resolution perspective. But I think all of what we discussed in the webinar, that at the agreement drafting stage itself, make sure that you have an effective dispute resolution mechanism, because that also works as a deterrent for parties to breach from parties breaching their obligations. So make sure that you have an effective dispute resolution mechanism, and that will go a long way in serving as a deterrent from parties raising frivolous disputes.
Perfect. So, dot on time. Before closing, maybe we move to the next slide and we request our IT colleagues to bring up the poll slide on the screen. We'll request everybody to provide their feedback on today's webinar. This is something which helps us in evaluating our efforts and also deciding on how to best present newer and newer initiatives to you. Great. If we can bring the slides back, and perhaps a few key takeaways from my side, because I thoroughly enjoyed listening to Anushka's presentation today, and obviously all of the incisive questions. And no one expects their counterparties to act in bad faith. You expect them to hold true to their obligations under contracts, but circumstances change. And even otherwise well meaning counterparties may need to default or may inadvertently or otherwise default on their obligations for several factors. There's now a wide menu of dispute resolution options available, and it's advisable to select what mode, what forum, and what method works best for the parties' combined collective priorities to provide for effective and expeditious resolution. For this, ladies and gentlemen, you need experienced advisors who have lived through the life cycle of such transactions and can help preempt at the very outset what complexities may arise in the future and how to best address them. So, with that, thanks to everybody who attended, thanks to everyone who participated in the poll. More importantly, and most importantly, many, many thanks to you, Anushka, for sharing your expertise and experience with us today. Absolutely outstanding. Thank you so very much. Um, and to our audience, thank you again for attending. We hope this was a worthwhile investment of your time. After the webinar, we will send you a copy of the presentation materials, the summary notes, and a link to the recording. We will also send you a separate request for a slightly more detailed feedback form. Please take the time to send that to us. If you are interested in in-house training or other matters arising from this webinar, please do not hesitate to contact us. Our contact information is on the slides in front of you. Thank you for attending today, and we look forward to being with you again at the M&A Academy.
Thanks, Samir, and thanks to all the participants.